Do children have a voice in the divorce and custody process, or can they have a voice in the divorce and custody process? The answer is yes. The paramount consideration in determining what visitation schedule is best for a child is the best interest of the child. And there's case law, one case in particular called the Holly case, that enunciates a number of factors that courts are to consider in making that best interest determination. And one of the factors the court considers is the desires of the child. So how do you register that with the court? Well, it's certainly not by having your child testify in court. Most judges frown upon that. Most parents do not want to involve their children that directly in the divorce process. So if a child is not testifying, how are the child's wishes heard? How are they considered? Well, the main mechanism we have for that is filing what's called a motion to confer. And a motion to confer can be filed by either party in the divorce, or if it's not a divorce, a standalone custody action, asking essentially for the judge to interview the child regarding the child's wishes for the visitation schedule or conservatorship. The law provides that if the child is at least 12 years of age and either side files a motion to confer, the judge has to interview the child. There's no discretion for the judge. If the child is under 12 and a parent files a motion to confer, then it's at the judge's discretion whether to interview the child or not. I've seen judges interview children as young as 9 regarding their preferences. There's really no rule of thumb as far as what is the cutoff age for how young a child can be and still be interviewed by the court. It's ultimately at the judge's individual discretion. Now, does that mean that the child's preferences, if the child says, I want to live with mom or I want to live with dad, are those preferences binding on the court? No. Ultimately, the judge has to make his or her own judgment about what's in the child's best interest, and a judge may ultimately determine that what the child wants is not in the child's best interest. Maybe the child wants to live with a parent that's unfit, or maybe the child wants to live with the parent that doesn't make him do his homework or go to school or whatever it may be. We don't let children have the final say on these issues. We ultimately defer to judges, but the child can still have a voice. The judge is still going to consider the child's wishes. And I would say that generally speaking, the older a child is, the more likely it is that the judge is going to respect the child's preferences. It's also important to note that we don't know as lawyers what happens during those interviews. You can, under the law, request that a transcript of the interview be made. Judges generally discourage that. Lawyers, because they know that judges don't like that, don't typically make a formal request for a transcript. So we don't know what questions a judge is actually asking the child during the course of this interview. Some judges may not even directly come out and ask the child who the child wants to live with. They may ask them about their school or just questions about the home dynamic in general. But to the question of, do children have a voice? Yes. And that's typically the way the voice is registered, is by filing that motion to confer. Another way that children's preferences are registered with the court is if the court appoints what's called a guardian ad litem. So if you have a high conflict, contentious custody case, lots of allegations being made back and forth between the parents, he said, she said kind of a scenario, the judge may appoint, whether the parties want one or not, what's called a guardian ad litem, which is an independent professional who comes in and conducts an investigation of what's happening at home. And as part of that investigation, the guardian will generally interview children that are at least 4 years of age. And through that interview process, the children will often tell the guardian ad litem what they want, which parent they want to live with. The guardian will also interview what are called collateral witnesses, like teachers or other caregivers or the pediatrician or other extended family members who may have personal knowledge and insight about the family situation. And then once the guardian conducts the investigation, the guardian will prepare a report summarizing her findings, identifying the people that he or she interviewed, and then making recommendations to the court regarding conservatorship and what the the visitation schedule should be. Now, the guardian's recommendations are not binding on the court. Ultimately, the judge has the final say regarding these issues. It's the judge that's going to determine what the schedule is going to be. But as a practical matter, I can tell you that based on my experience, more often than not, a judge is going to endorse and adopt whatever recommendations are made by the guardian, because judges, they have faith in guardians, they trust them, and guardians are perceived as neutral. Clients don't necessarily agree with that. Invariably, a guardian is going to upset one parent, and the parent who doesn't like the recommendations is going to be convinced that the guardian is in the tank or being influenced or is biased. But from the perspective of the court, guardians are neutral and unbiased, and their recommendations are based on what the guardian sincerely believes to be in the child's best interest. And more often than not, the judge will ultimately adopt those recommendations and make those the final order of the court.